Important changes in Australia's workplace laws that affect security employers and employees covered by the National Workplace Relations Systems came into effect from 1st of January 2010. The Australian Security Industry Association Limited, ASIAL, in conjunction with the Fair Work Ombudsman, have created this series of 6 short videos to help you understand your employer responsibilities under the new National Workplace Relations System. These changes include the commencement of the Modern Security Services Industry Award 2010 and the introduction of the new National Employment Standards, NES.
The Security Services Industry Award 2010, like all modern awards, has a clause dealing with flexible working arrangements. These arrangements are meant to meet the genuine individual needs of the employer and the employee. The terms that may be varied are those concerning arrangements for when work is performed, overtime rates, penalty rates, allowances and leave loading. Any variation cannot leave the employee worse off than they would have been under the award, and either side can opt out of the arrangement by giving the other 1 month's notice in writing that they want the arrangement to stop. If you are thinking about making an individual flexibility agreement, it is best to contact ASIAL before you enter into an agreement. All modern awards have a clause dealing with consultation. This requires that where an employer has made a definite decision to introduce major changes that are likely to have significant effects on employees, the employer must notify the employees who may be affected by the proposed changes and their representatives, if any. The employer must discuss with the employees affected and their representatives the effects the changes are likely to have on them and measures to avert or mitigate the adverse effects of the changes. The employer must give prompt consideration to the matters raised by their employees or their representatives in relation to the changes. All modern awards have a clause dealing with dispute resolution. In the event of a dispute about a matter under this award or a dispute in relation to the NES, the parties must attempt to resolve the matter at the workplace by discussions between the employees concerned and the relevant supervisor. If these discussions do not resolve the dispute, the parties will endeavour to resolve the dispute in a timely manner by discussions between the employees concerned and more senior levels of management as appropriate. If a dispute is unable to be resolved at the workplace and all appropriate steps have been taken, either party may refer it to Fair Work Australia. The parties may agree on the process to be utilised by Fair Work Australia, including mediation, conciliation and consent arbitration. While the dispute resolution procedure is being conducted, work must continue in accordance with this award and the Act. Need more information? A full guide to the Security Services Industry Award 2010 is available at www.securityindustryaward.com.au. If you require a printed version to be posted to you, or you have any questions relating to this presentation, please contact ASIAL's Fair Work Liaison Officer Chris Delaney on 1300 1 ASIAL.